Good morning, good afternoon, good evening, depending on what part of the world you are in. This is the Big Girl Diary. My daughter's cat. Look, Evan. Evan Rachel Wood. You can't make that stuff up. Oh, look. It is on. Evan Rachel Wood wrote a check that her butt can't cash. Oh my goodness. Marilyn is bringing the fire. Oh. And I got the court documents that dropped yesterday. I spent yesterday and today going through it. Yes, I have all kinds of marks all over it so you can see it. I can see it and see how delusional. Oh my goodness, her delusions has no bounds. I don't know where or what planet she's on, but it's not on Earth. Let's get it started. Okay, this is going to be a long one today, and I'm going to put timestamps on it. The court document is 22 pages long, and I screenshot everything. We're not going to go through everything, only the things that I thought that were important, but watch everything. Those of you who do not believe Marilyn Manson, you might want to pay special attention to this. You really do, because then you're going to see the person who you are giving all your blind loyalty to. You're going to, hopefully, you may open your eyes up a little bit, because women are running around delusional and they are destroying men's lives because they can. And they're running around unchecked. That's my public service announcement. All right, here we go. Look, I'm not a lawyer. I know nothing about the law. I have $2.50 worth of law understanding. So silly, I'm sorry. Okay, hold on. All right. As you can see how I have everything circled and underlined. All right. The first is Wood's apparent disbelief that requesting discovery proves Warner's claim lacks merit. You can't make this stuff up. Oh, goodness. But this cannot be true, as discovery is authorized by statute. A trial courts are admonished not to abort potentially meritorious claims due to lack of discovery. Wood complains about sitting for the limited deposition now, but ignores that she will be subject to discovery even if she and Illma Gore prevail on their motion to strike, because Wood and Gore do not seek dismissal for Warner's claims. Wood also overstates the narrow scope of the 5 depositions sought, which in comparison confirming the handful of facts through evidence or through admissible evidence unavailable to Warner. Authenticating documents. Wood's suggestion that Warner seeks evidence to prove every element of every claim is baseless. You can't make this stuff up. The second deflect arises from Wood's reliance on her vague, self-serving testimony that denies her participation in certain acts. The defendant declaration denying that he or she engaged in the conduct alleged in the complaint does not foreclose the possibility that a fact finder could later find that he or she did in fact engage in the conduct, foreclosing an anti-slap motion based upon one version of the facts would irrationally and unfairly disregard this possibility. Wood is correct that the declaration exonerates her from liability on the challenged claims. Gore offers no testimony at all. Wood fails to explain why none of the requested discovery is necessary and relevant to to all of the same claims plead against Gore. This is really interesting. The opposition of the third crucial flaw, Wood's failure to apply the correct legal standard to Warren's prima facie, that under the anti-slap statute, second prong, only cause of action lacking even minimal merit may be stricken, and is making the determination the court does not weigh evidence or resolve conflict factual claims. Instead, the court accepts as all evidence favorable to the plaintiff and assess the plaintiff's or the defendant's evidence only to determine if it defeats the plaintiff's submission as a okay. Did I go back? Okay. The three deposition flaws run through Evan Rachel Wood's opposition. The first is Wood's apparent disbelief questioning or that requesting discovery proves Warner's claim lacks merit. A trial court are admonished not to abort potentially meritless claims due to the lack of discovery. Wood complains of Okay, the opposition's third critical flaw results in Wood's failure to apply the correct legal standard to Warren's facie case under the anti-slap statute second prong. Only causes a lack of action lacking even minimal merit may be stricken. And in making the determination, the court does not weigh the evidence to resolve. Instead, the court, matter of law. The court also must not weigh the credibility of evidence to determining whether Warner can make a facie case. Throughout the opposition, Wood urges the court to violate the rules and commit error in discounting Warner's evidence and accepting Wood's interpretation of the same evidence instead. Wow. This is wild. Her delusions. Okay, a good case standard is not actually in dispute. Wood's opposition proceeds from the spacious from the specious argument that by asking for discovery, Warner is somehow admitted his claim to be dismissed. Wood's opposition proceeds from the specious arguments that by asking for discovery, Warner has somehow admitted his claim should be dismissed. The court's on notice and for good cause, showing that many orders that have specified discovery be conducted, notwithstanding the automatic discovery stay set forth in this subdivision. You can't make this stuff up. Oh, man. That said, Wood does not dispute that to demonstrate good cause, discovery, Warner must only explain what additional facts he expects to uncover through narrowly tailored discovery. 2, explain why does the facts why those facts are necessary to carry his burden in opposing to the anti-SLAPP motion. 3, show his claims are legally sufficient and demonstrate that he can make the facie and showing all of the other elements in his claim. Warner satisfies this prerequisite. Disposition are narrowly tailored and responsive to the motions. The limited discovery Warner seeks, 2-party and 3 non-party depositions, but no documents requested or written discovery, and narrowly tailored and responsive to Wood's and Gore's motions. Wood's opposition does not dispute that 1, Warner explained what additional facts he expects to uncover. 2, for each fact, and Warner identifies and claimed elements it supports. 3, for each claim element, Warner identifies where in Wood and Gore briefs it is raised. 4, the identified fact do not extend beyond the elements of this prima facie case. 5, the fact Warner seeks through his sanction or through his section requests are not otherwise available to him. Wood argues the request deposition are unprecedented and unbound and extensive. Wood cannot cite any authority supporting her assertion about the five depositions are improper. In fact, she contends elsewhere that discovery should be denied because Warner has not asked for enough depositions. This is no basis for Wood to claim the depositions that are unbound and extensive neither. Warner's motion sets forth the bounds and the depositions and show Warner has adjudication in identifying the request scope, the requested scope. Interesting. Whew. Issues. Okay. Wood ignores that Gore's deposition not cover the majority of the facts sought, necessitated in part by Gore's lack of sworn testimony. Wood also ignores the fact that all three of the non-party witnesses should not give declaration voluntarily. And for Wardner to obtain their testimony now is by deposition. Plaintiff knew which reporter had the information he needed, could have sought declaration from them. Wood cannot seek. Did I read this? Okay. Wood cannot seek dismissal of Warner's claims based on her mischaracterization of it. The complaint mistakenly alleges that Warner's claim arises from forgetting or forging the fake FBI letter and using the letter to make up investigation to recruit potential accusers, out not filing the fake letter and a perjured declaration in Wood's custody proceeding. Now, remember when I told you last time about how Marilyn could use this against her by her taking the letter, the fake FBI letter, into her custody case against her ex-husband, and her ex-husband can turn around and use this against her by saying that she's either lying and making this up, which is still bad on her part, and it shows poor character, or that she has lost her grip and he's concerned for your son's safety. That's exactly, she's done. Okay, custody proceedings. Wood fails to address the plain language of the complaint, drawing this distinctive, and instead just reassert that she and Gore could be excused from the illegally impersonating and the FBI agent because Wood also filled the letter by her parentage actions. You're not getting out of this. You are not getting out of this. Okay, Wood and Gore's wrongful conduct in furtherance of their conspiracy is staggering. Impersonating an actual agent of the Federal Bureau of Investigation by forging and distributing the fictitious letter from the agent, and forged letter would be used to recruit, encourage, and convince people to the claim were abused by Warner, because they were led to believe that Warner was a threat to their safety and under the federal investigation. This is wild beyond belief. This is wild. Warner seeks discovery. Wood fails to show that Warner has not made and cannot make a prima facie showing. She argues Warner has not alleged the required causal nexus between the alleged outrageous conduct and his purported distress. But this is set forth to his declaration. Wood offers no authority allowing the court to discredit let alone ignore Warner's declaration, nor can she. This is wild. Wood's own carefully drafted declaration claimed she did not fabricate the FBI letter and believes it to be authentic, where she received a copy and submitted it to the court. It, at most, it creates a factual dispute, which at this stage must be resolved in Warner's favor. So Warner wins this. Wood does not deny the participation in drafting the letter, nor does she dispute the letter was created by someone other than its purported signatory. FBI agent Michelle Langer. Neither Wood nor Gore addressed the incontrovertible fact that the FBI letter is fake, nor do they dispute Gore's involvement in the forgery, aside from the encouraging of the court to err by weighing certain evidence. Wood's attempt to characterize some evidence that establishes Wood's collaboration with Gore on the fake letter, while ignoring other facts of the same thing. She also ignores evidence that multiple people told her the letter was inauthentic, but did nothing about it. While the requested discovery goes to warn prima's facie, showing to defeat Wood's motion under the anti-SLAPP analysis, the second prong, the court will not get there, whereas Wood's motion to fail under the first prong. She just loses. Illegal activity. It is not a constitutional protected exercise of the right to petition for free speech. You can't do that on a lie. You just can't. Warner does not need to conclusively prove that Wood forged the letter, Warner does not need to conclusively prove that Warner forged the letter or knew it to be forged when she filed it. He needs to show only the claim protected activity is illegal as a matter of law, neither because the evidence conclusively established the defendant concedes illegality. Defendant's argument that its evidence shows it did not do the act that plaintiff alleges did is more suited to the second step of the anti-SLAPP motion. There is no dispute Agent Langer did not write, sign, or authorize the letter, even though it purports she did. Wood nor Gore seriously contend that forging the letter is impersonating Agent Langer is not a criminal act. Gore says nothing about it, and Wood, for her part, only tries to downplay the lack and intends to defend and deceive elements in by claiming she could not have had the required mens rea the defendant's knowledge that she is not only the officer or the employee of the United States, which Wood, for obvious reasons, does not dispute. Wood nor Gore even attempt to contest the forging was illegal under California law. The claim protected activity is conclusively illegal. Wood's argument that Warner should not get discovery because he has no admissible evidence that she would pressured people to lie about Warner's involvement. Wood again disregards the relevant legal standard. Wood's self-serving testimony that I have never pressured anyone to make false accusations against Mr. Warner cannot supplant the evidence. But even if it could, Wood's denial is not coextensive with the conduct alleged to be outrageous. Reoccurring, coordinating, and pressuring multiple women to make false statements again. This is just so terrible. Oh my goodness, poor Marilyn. Wood also urges the court to err by assessing credibility and accepting her interpretation of the evidence. Warner has denied the accusation of abuse, whether or not it was outrageous to recruit. Wood does not dispute Warner can make a facie case of defamation and LLED against Gore. Wood's argument boils down to contention that Warner is not entitled to discovery because she does not make the defamatory statements. Wood was somehow removed. She cannot explain why discovery that is relevant and necessary to those same claims against Gore could be denied. Warner does not seek Wood's deposition on Gore's topic. So it is not clear what her issue is. Wood does not have liability for the defamation of the LLED claims, even if Gore's uttered the defamatory statement, which Gore also did not dispute uttering. Wood does not even have to make the statement herself to be liable. She can be vicariously liable as Gore's principal or as Gore's co-conspirator. Contrary to Wood's argument that discovery should be denied because the complaint fails to state a cause of action based on civil conspiracy. There is no cause of action for civil conspiracy which to state. Okay. The complaint more than sufficiently alleges a conspiracy by Wood and Gore to publicly cast Warner as a rapist and abuser, a malicious falsehood that has derailed Warner's successful music, TV, and film career. in furtherance of which Gore and Wood committed numerous wrongful and illegal acts. The complaint alleges each of the former of the group of the two or more persons who agreed to a common plan or designed to commit a torturous act, a wrongful act committed pursuant to an agreement, resulting damages. Oh goodness. Wood fails to appreciate that the conspiracy's extent is often inferentially and circumstantially derived from the character of the acts done, the relations of the parties, and other facts and circumstances suggestive of the concerted actions. Gore's defamation of Warner was within the ambit of the conspiracy, and thus Wood may be liable. Wow, you can't get out of that. We needed to have made the statement herself to be liable for it. She can be vicariously liable. Liable as Gore's principal or as Gore's co-conspirator. Wood's argument that this discovery be denied because the complaint fails to state a cause of action based on civil conspiracy. There is no cause of action for civil conspiracy which is not true. Okay, the doctrine of liability and not a cause of action. Okay. All right, so that's all of it. Oh my goodness. Oh man. What do you think? I am so sorry, my eyes are so tired and what's here is so small. But when you see it, it's like this. So please do forgive me and don't judge me too harshly. Please don't. But that was everything that... Oh man. Look, Evan, you wrote a check that your butt can't cash. You are not only going to get slobber knockered by Marilyn Manson, but now your ex-husband has just cause to go back through the courts. And again, I'm not a lawyer. I have about $2.50 worth of understanding of the law. And he can come by and see all this mess that you caused to take a man down, and then you want to use that in a fake FBI letter into another court case. Not to mention now, Senator Rubio over in California is catching heck for the Me Too movement, and this is what I predict. And I really hope that I'm wrong. I really am, because women who are being abused and having these issues, they're going to have problems because of women like you. You go out here and you tell these outlandish lies to get back at someone because he married another woman. That's what it all boils down to. That's what I believe. And you're going to get sued. This right here, I believe, can be life-changing results. Look at Amber Heard. 4.8 million people signed what is it called, a petition to keep her from being in Aquaman 2? 4.8 million people do not want to see you in Aquaman, do not want to see you in a hemorrhoid commercial, do not want to see you walking down the street. Oh, Evan. Oh, what a web you have woven. And Illma, she put little in there. Okay, on that note, please like, subscribe, and I have more. This one is only 8 pages, not 22. Thank goodness, 8. I need to decompress from this one. I wasn't expecting all that. So please like, subscribe, and I want to thank my subscribers. Thank you so much. And those of you who were on the edge, please subscribe and like and put something down there if you choose to. I know this was long. I wasn't expecting to be close to 40 minutes. So it will be time stamped. Oh, that's painstaking. But on that note, I want to thank all of you for stopping by.